So employees sue when they're unhappy, and they're unhappy when they get fired. But there's no cause of action in New York for unjust dismissal or wrongful termination. So claims that get raised after somebody gets fired they fall into two buckets: either some sort of statutory discrimination or retaliation claim, or breach of contract, right? So offer letters or employment agreements are one way that employers can lower the risk that there's a breach of contract claim. And what I mean by that is, you need to spell out clearly what happens. You can terminate this person with or without cause. Is that true? Is it not true? Is there severance? Is there not severance? How's the comp? Is it discretionary? If it's guaranteed, what does that mean? Does the person have to be there? Everything should be spelled out. It's like your prenup. And then when the person leaves, you're like, okay, this is what you get. And you don't have you don't have a breach of contract claim. Statutory claims, a little more difficult to try to do anything with in the offer letter itself. The one thing that a lot of employers use, and particularly firms in this industry, is they do require arbitration of statutory employment disputes, which is private, as opposed to disputes being heard in a public setting in state or federal court. A lot of employers use that. It's not so bad. It's a real trial in front of a panel or an arbitrator who is a neutral. What I have been seeing, just if you want to say the trend, there have been arbitration provisions have been attacked in the courts repeatedly for statutory claims since like 1991, when the Supreme Court kind of put it to rest. There's attack. All these attacks have failed. But we have been seeing some tweaks by our legislators. So, for example, whistleblower retaliation claim under Dodd-Frank, that can't be arbitrated. It's right there in the statute. And just a week or so ago, our governor said he wants to not allow arbitration for sexual harassment cases. He wants them to be public. So who knows where these things will go, but that's one thing. You try not to get sued for discrimination by having policies and procedures in place and doing the right thing. The other thing you need to do with your offer letters is you need to make sure that you're technically compliant with the law on the day you issue that offer letter. Things have been changing very quickly, and some of these things have gone unnoticed. For example, New York law prohibits confidentiality provisions that say the employee can't talk about her own compensation to other people. The National Labor Relations Board has weighed in on terms and conditions of employment, saying you can't have a confee that says people can't talk about the terms and conditions of their employment with each other in the workplace. The SEC has attacked provisions in offer letters, things that inhibit whistleblowing, certain types of confees. New York City has just been very busy onboarding. So no credit checks for most physicians anymore, and no pre-offer criminal background checks. So these are developments that kind of come quickly and affect the terms that are put into people's offer letters, and that if they're wrong, could be a headache down the road.